Welcome back to the second segment of this ELS law session in relation to answering exam questions posed on a CLRI paper. Now, we are going to consider, of course, a question in relation to the Supreme Court, and in particular, we're looking at a question 6, which was posed on the University of London LLB's international program in 2010 CLRI exam paper, and the question says, the role and functions of a court of appeal and the Supreme Court are different. So, the role and functions of a court of appeal and the Supreme Court are different. That's the first statement, and there's a full stop. So this is a two-part statement, and this was the point I was making in the first segment, is if you are going to flag something up in terms of your answer, something that's non-contentious, you can pretty much agree with that part of the statement. But then look at the second part. So the first part says, the role and function of a court of appeal and a Supreme Court are different, full stop. The United Kingdom has created a Supreme Court in name, but not in function, semicolon. So, the United Kingdom has created a Supreme Court in name, but not in function. It would be better if no change had been made. Discuss. Now, you see what the examiner has done. He's given you a question where he gives you a non-contentious statement in the first sentence. Then he makes a statement that appears slightly inaccurate, somewhat accurate, somewhat discussive. And then he says, he goes for the jugular and says, well, it would have been better if they had done nothing. So it talks about the functions of a court of appeal and the Supreme Court are different. Then it goes on, the UK has created a Supreme Court in name, but not in function. It would have been better if no change had been made. Discuss. All right then, how do you tackle that? Well, it's a very good question indeed for you to be able to display your research and analysis skills. Now, you do have some questions, particularly when you're looking at English legal system, CLRI, or you're looking at public law, where your personal research in keeping track of recent events will go an extremely long way in assisting you in raising your marks. Because when you look, for example, at certain areas which are trending, for example, when you look at 2010, the Supreme Court sort of starting their work in 2009, that would have been a flurry of discussions going on about this, and so there would have been a lot of material for you to be able to make some solid notes on that. So, for example, if you were sitting exams soon in respect of looking at an area, for example, when you look at something like, say, human rights and, say, prisoners being able to vote, for example, or being able to, partake in the voting process, there's again a lot of discussions out there about whether this is or this isn't right to be done. So the point I'm making is, when you're looking at, for example, the Supreme Court, you do have commentators who are saying, well, this was just a load of rubbish. We should have just left it where it is. The British legal system is such that, it's traditional and all of this. And you see the discussions there. What you would have needed to do as you were doing your reading coming up to the exams, you look at things like the daily newspapers, broadsheets, newspapers like the Telegraph, the Guardian, the Times, bbc.co.uk, and looking at what commentators are saying about it to then form your own opinion as to which discussions make sense or which ones you agree or disagree with. So you had to consider the framework of the UK court system. Now then, what would you need to look at? You would need to know what is an appeal court. You would need to know what is a Supreme Court. You would need to know what are the functions and role of the two. So what we see, a statement is made, and that is that when you look at the role and function of a Supreme Court is different from an appeal court. Now, that in itself, you could say, well, yes, that's not contentious because an appeal court exercises appellate jurisdiction. When you look at a Supreme Court, in most jurisdictions, one of the key differences, they do operate as an appellate court as well, but where you're looking at them operating or exercising functions beyond an appellate court is where, for example, they are able to strike down unconstitutional legislation. So this is where, for the first statement made, you shouldn't have a difficulty in saying, well, yes, the statement made initially is largely correct, and say why. And you would, of course, have to give a definition. Then, of course, it looks at this idea that the UK has created this Supreme Court in name only. So you would then have to draw on the definitions you've advanced for a Supreme Court and see if what the UK has done in respect of the Supreme Court fits in that mold. And then, of course, we see this very provocative statement, it would have been better if no change had been made. Now, what do you think? Now, remember, in your law exams, you do not put, I think so-and-so, or I believe that, or I would have thought that. No, you still have to make submissions. You have to speak like a lawyer, write like a lawyer. And that requires formality, writing in the third person, and making sure that you give a detached discussion, but it still must have some passion about it. Now, what you need to look at, for example, is this idea about the House of Lords, which of course is the predecessor of the Supreme Court. What about the fact that the House of Lords sat in the legislative upper chamber? How would you deal with that? So in an introduction, for example, you might start with something along the lines of something which says, whilst the first statement appears a truism, taken as a whole, the entire statement does not necessarily appear accurate. Indeed, the role and function of an appeal court is largely to exercise appellate jurisdiction for lower courts. Conversely, a Supreme Court suggests a more constitutional role with the ability to scrutinize and, where possible, intervene in constitutional and unconstitutional matters. The Supreme Court in the UK has been the result of an evolution in the UK which has seen a physical change. However, whether in substance, that is, whether it has been more than a name change, has to be analyzed and further reviewed as to whether maintaining the status quo would have been better. That for me would be an introduction. So it's showing the path to the examiner that you're going to take. So you could continue something along the lines of, and again, I'm not giving you canned essays, something to regurgitate. I'm trying to make you see what legal writing is about. So for example, if we look and we carry on and we said, for example, in 2009, the Supreme Court of England and Wales came into being, moving into new premises in the London Guildhall and discarding its cloak and nomenclature of the House of Lords, etc., etc., etc. And you carry on to show your knowledge, but overlaying it onto the question asked. Now, when you look at the answering and moving along the path, remember that you show the path as to what you feel, your discussion, the path that your discussion is going to take, and you show the definitions, and those are necessary. So you could look at the functions of the House of Lords had been not only to consider appeals, you could say, but where difficult areas of law required intervention, this was undoubtedly considered. For example, when one considers a case such as Anis Minnick and the FCC. The fact, though, is that given parliamentary supremacy, the role of the Supreme Court is arguably of an appellate nature, as unlike in the United States, where unconstitutional laws can be struck down, that cannot be the case in the UK. And that now sets up the examiner, sets you up to show the examiner that you are going to now discuss that it is by and large a whole different kettle of fish when you look at the Supreme Court and an appellate court and looking at how this pans out in the UK. Of course, you would have to show that briefly though, you would have to show that there have been times when the court has said that something is not correct. It has taken an apparent constitutional stance. For example, like in the case of R&R. But the problem there is it that the courts are acting in a constitutional manner, or is it that the court is doing no more than, for example, interpreting the law, and it is under their interpretative functions that they have managed to then come up with something that appears constitutional? So when you look at that framework and you've given that to the examiner, then you move on to looking at what a Supreme Court really does, and say, for example, showing the examiner, so say what the difference is in that regard. So go on, discuss the differences, and you raise as well any cases that show this conflict with parliamentary supremacy, and why this whole idea of a true function of a Supreme Court is difficult in the UK's framework, cases like Burma Oil and Lord Advocate. So in the structure of your answer, you should have, say, by paragraph 3, given an indication as to the arguments in favor of the position you're going to take, and maybe do a couple of paragraphs on that, and by around, say, paragraph 5, do a couple of paragraphs which go against your argument. So you should know that if you're saying, well, it's not truly a Supreme Court, could somebody else argue that it is a Supreme Court and what it does? So you should know the shortcomings of your own position. Now, I am from the school of thought that you should make submissions in favor of a position, although of course you will get examiners who will say you don't have to focus on or lean in favor of one side or another. You can simply advance the arguments and then conclude. Well, my suggestion is it gives it a bit more bite and passion if you're able to bolster the position that you're taking. But that is my personal view, and you have to see what works for you personally. Now, that is my suggestion in relation to that particular question, and we are of course going to go into a short break, and when we come back I will focus on a question relating to precedent. However, if you are signed up to our premium service, you can contact us and request a copy of a sample answer to this particular question, which I have written under timed conditions in less than 35 minutes. So it is not the type that you would see in a Q&A, but something that is written under time conditions without sight of books or anything like that, to try and give you a flavor of how to answer this. So after this short break, we will look at a question which focuses on precedent.